So I'm sure you have heard of the FAL convention, which stands for Facilitation of Maritime Traffic. Today's video is on the PAL convention. The PAL convention is also known as the Athens Convention, relating to the carriage of passengers and their luggage by sea. Now today's video could have become very long, but I will try to keep it short, either by speaking fast or by summarizing the slide. I will at times also read out from the slides because you need to understand some of the technical language here. Otherwise, if I use my own English, sometimes the meaning of the convention can get lost. So this convention was adapted in 1974 and it entered in force in 1987. Took it a long time for it to enter into force, about 13 odd years, and throughout from 1987 it was amended. In 2002, 2014 it was being amended through protocols. So what is the convention all about? The convention was adopted at a conference in Athens and it was designed to harmonize two earlier conventions that related to the carriage of passengers and their luggage. Alright, this convention established a regime of liability for damage suffered by passengers carried on a sea-going vessel. So if I can explain this simply to you, liability always refers to responsibility. So this convention established who will be paying for the damages as incurred by the passengers if they are being carried on a sea-going vessel. It declares a carrier liable for damage. So the ship owner will be liable for the damage, will be responsible for paying for any loss or damage suffered by a passenger if the incident causing the damage occurred in the course of the carriage and it was due to the fault or the neglect of the carrier. So when we say carrier, we mean ship owner. When we say ship owner, we mean the officers and crew of the ship. So because of their neglect, if the passenger suffers any loss or damage, then the ship owner will have to compensate by paying, or by other means they might have to compensate to the passenger. However, unless the carrier acted with intent to cause such damage or recklessly and with knowledge that such damage would probably result, he can limit his liability. So if the carrier or the ship owner can justify that the loss or damage was not due to neglect, or it was not due to ignorance, it happened due to an act of God, it happened due to circumstances beyond the control of his officers and crew, then they can reduce the amount of payment that they are supposed to be giving to the passengers. So in this case we referred not to dollars, but we refer to something called SDR. SDR is not Singapore dollars. SDR refers to special drawing rights. This is a kind of a currency used for calculation of the liability. Now as you can see, the liability limits were set at different rates. It was initially started at 46,000 SDR, and then in 2002 protocol, when the protocol entered into force, compulsory insurance was also included to cover passengers on ship, and that raised the limit of liability to 250,000 SDR per passenger on each distinct occasion. As far as a loss of or damage to luggage is concerned, the carrier's limit of liability varies depending on whether the loss or damage occurred in respect of cabin luggage, of a vehicle or a luggage carried in or in it, or in respect of other luggage. The 1976 protocol made the unit of account the special drawing right, or SDR, replacing the previously established Poincare franc. Now that's a very bad pronunciation, it's a French word. It was based on the official value of gold. Or like I said, in 2002 it was again, this convention was amended. It entered into force 12 months after being accepted by 10 states. This protocol introduced compulsory insurance to cover passengers on ships and raised the limits of liability, as I've already told you. It also introduced other mechanisms to assist passengers in obtaining compensation based on well accepted principles in existing liability and compensation regimes. These included replacing the fault-based liability system with a strict liability system for shipping related incidents. So basically here the fault finding or blame game will not be accepted. If there is a damage and the passenger has lost luggage, or passenger has incurred damage or loss of any kind, the ship owner cannot waste time in playing the blame game. They will have to compensate, or they would have to pay some kind of a compensation to the passenger. This protocol also included an opt-out clause which enabled the state parties to retain or introduce higher limits of liability or unlimited liability in the case of carriers who are subject to the jurisdiction of their courts. Compulsory insurance, I've already talked about this. Basically, the limit of the compulsory insurance, I'll just summarize it, was not to be less than 250,000 SDR per passenger on each distinct occasion. The limits of the liability were raised significantly. The liability of the carrier for the death of or personal injury to a passenger is limited to 250,000 SDR. If the loss exceeds the limit, the carrier is further responsible or liable up to a limit of 400,000 SDR per passenger, unless the ship owner or the carrier can prove that the incident which caused the loss occurred without the fault or the neglect of the carrier. Then he can reduce it to maybe 250,000. All right, but it has to be minimum at 250,000 and then maximum up to 400,000 STR. So here the carrier can do some kind of a bargaining, but they have to prove that the loss or the damage to the passenger was not due to neglect or fault of their own self. In the case of a death of or a person injury to a passenger not caused by a shipping incident, the carrier is liable if the incident which caused the loss was due to the fault or neglect of the carrier. The burden of proving fault or neglect lies with the claimant. So it will lie with the passenger. It will lie with the person who is claiming for the compensation. They'll have to prove that the fault or the neglect was of the ship owner. The liability of the carrier only includes loss arising from incidents that occurred in the course of carriage. So for example, if it is on the ship, only then. If it is outside the ship, if it is during when they are roaming around in the city or in the town and something has happened, then the carrier is not liable. But the carrier will be liable only if, even in town, even if away from the ship, off the ship also, if something has happened due to the fault of the carrier. If it has happened to a third party, then the carrier of course not liable to be paying for those damages. The opt-out clause, I've already told you about that, but the opt-out clause allowed a state party to regulate by specific provisions of national law the limit of liability for personal injury and death. Now this is of course the to protect the ship owner, because it cannot be unlimited liability. The ship owner had to they have to set a limit so that the ship owner doesn't go bankrupt if there are thousands and thousands of passengers who are claiming for some kind of this loss or damages. Then there has to be some limit up to which the ship owner should have to pay for the liability or the damage to the passenger. In terms of liability or loss of damage to luggage and vehicles, the liability of the carrier is limited to 2,250 SDR per passenger per carriage. The liability of the carrier for the loss of or damage to vehicles, including all luggage carried in it, or the vehicle, is limited to 12,700 SDR per vehicle per carriage. And liability of the carrier for the loss of or damage to other luggage is limited to 3,375 per SDR per passenger, which is not in the vehicle. Finally, the carrier and the passenger may agree that the liability of the carrier shall be subject to a deductible not exceeding 330 SDR in the case of damage to a vehicle and not exceeding 149 SDR per passenger. So this means up to that amount the passenger can cover for himself, but after that the carrier should have to pay for the amount exceeding these ones. So anything more than 330 and more than 149 SDR will be covered by the carrier then. So this could be a contract. This could vary between the passenger and the carrier, but depending on the contract or the between the passenger and the carrier here, some of the amount may not have to be paid. If it is very less, then the ship owner doesn't have to be paying this amount, but anything more than this amount will have to be paid by the ship owner. So these are basic principles of marine insurance. Alright, then again we can go further into the details of it, where the 2002 protocol introduced a tacit acceptance procedure for raising the limit of liability. So basically here it was requested to at least one half of the parties to the protocol to discuss on this kind of a tacit acceptance procedure. So the deemed acceptance date would be 18 months after the adoption, unless within the period, if more than not less than 1/4 of the states refused to accept the amendment. So this amendment was that it introduced a new procedure for amending the limits of liability under the convention, so that any future raises in limits can be achieved more readily. So for that, of course, the ship owner had to agree to it, and which was not an easy thing to achieve. For the first time in an IMO convention, a regional Economic Integration Organization may sign up to the protocol. An article in the protocol states that a regional economic integration organization, which is constituted by the sovereign states and that have transferred competence over certain matters governed by this protocol to the organization, may sign, ratify, accept, approve, or accede to the protocol. So the states don't get involved in directly, but rather the organization will get involved and they take decisions based on the states. Finally, I don't think this is very important. What you have to finally know is the structure of the protocol. We have known about this. Then also the aim is to put states in a position to ratify the protocol and therefore afford passengers better cover. So as the years are going by, more and more better cover and insurance and liability requirements are coming out that protects the rights of the passengers. We also have a publication called the Guidelines for the Implementation of the Athens Convention to allow limitation of liability, and not a publication but rather a guidelines here, and these guidelines should be read and understood by the seafarer or by you if you want to understand this further in detail. Now, the text of the agreed reservation stated that the government concerned reserves the right to and undertakes to limit the liability to 250,000 SDR, of course, in respect of each passenger, or 340 million units of account overall per ship on each distinct occasion. Now, this depends on the contract and the agreement between the ship owner and the insurer, but this relates in particular to war insurance, which under the guidelines shall cover liability, if any, for loss suffered as a result of death or personal injury to a passenger caused by war, civil war, rebellion, insurrection, civil strife arising, capture, seizure, arrest, restraint, detainment, acts of piracy, acts of terrorism, so on and so forth. Finally, the SDR, if you want to know more about the SDR, you can find the daily conversion rates for the SDR into whatever currency you are interested in into the website of the International Monetary Fund. The website is www.imf.org, and there you can actually find out what the SDR stands for in terms of the currency of your interest. So if you want to find out SDR into US dollar, SDR into Australian dollar, you can go and find out that information from this particular website. So I try to summarize this convention for you guys. This is a pretty long convention, but for your orals understanding and to answer questions in the orals exam, as long as you know the gist of it, that this convention was introduced to protect the passengers from a loss of their own life or injury and the loss of their luggage and vehicles, and by holding the ship owner liable. And if you remember a couple of values of SDR, the limits of liability, the basic limits of liability, if you can remember the 250,000 SDR and how much it can go up to maximum, that should be good enough for you. So you don't have to go really into the depth of this convention, but as long as you have a basic understanding of this convention, you should be good to go. Thanks guys, and see you soon with my next video. Bye for now.